Uh, okay, the live stream is on. Vishal, you can start. Give the introduction of our guest speaker, and
Yes,
then
thank you, sir. Now
thank you.
we are moving to the next part of today's session, and it is my great privilege to welcome our distinguished speaker for today's Vihara session, Dr. Asang Wankhede, a postdoctoral research associate at the King's India Institute, King's College London. Dr. Asang Wankhede completed his doctorate in law at the University of Oxford in 2025, following an LLM in human rights, conflict and justice from SOAS, University of London, and BA LLB from National Law University, Delhi. Dr. Wankhede's work has made an important contribution to understanding caste and discrimination beyond India as well. His research on caste-based discrimination in Australia contributed to its recognition as a form of intersectional uh, racial discrimination within Australia's national anti-racism framework, and he has also engaged in anti-caste advocacy at United Nations human rights forums. We are truly honored to have him with us today um, as part of our ongoing Vihara discussion on the unconstitutionality of subclassification, a critical analysis in the light of Dr. B.R. Ambedkar's vision. Jai Bhim, Dr. Asang sir. We warmly welcome you to Vihara. Please start your session. Over to you, Dr. Wankhede.
Thank you. Thank you, Vishal, and Jebim to everyone and Jebim to you. I would like to start by thanking Anna for this kind invitation, and it is my pleasure to be here with all of you. Of course, I've heard about Anna and the good work that you have undertaken in the States, and many congratulations to not only the committee, the organizing committee, but each one of you. And thank you so much for joining today. As a lawyer, I know that we are very infamous in many regards for the language that we use. Sometimes it's not very clear for the non-lawyers. And my intention today, in the next 20 minutes or so, Vishal, is it okay? 20 minutes and then 10 minutes or 15
Yeah,
minutes we
you
can have a
have
discussion?
30 minutes for your session.
Okay, sounds good. Sounds good. So then I think I can then sort of cover about 20 minutes of what I will speak on the topic, and then 10 minutes we can have a Q&A. And my approach will be more uh, activist oriented and of course very rigorously academic, but I will not use any of the legal jargon which uh, uh, rightly so, should not be used in events like this. However, I've written quite extensively on this topic, and in particular, my whole PhD and my MPhil, my Master of Philosophy at Oxford, was focused on this very aspect of law, the constitutional law, as we try to understand the issue of uh, what is advantageous, who are people within the community or the scheduled castes, as we come from that community, scheduled tribe, OBCs. Um, and also, my research has been very much focused on critically evaluating how upper caste groups have tried to sabotage the reservation policy by co-opting it in their favor in various forms. My 2022 book, which came out with Routledge UK, critically argues against the upper caste capture of reservation policy in India. So let's begin with, and this is not an academic lecture or a law lecture that I usually give, but I think we have to really start with what is the reservation policy. Reservation policy in India, as many of you know, and I think every single one of you is a beneficiary of, I'm assuming, uh, is a form of affirmative action policy. And affirmative action policies are meant to are given to historically oppressed groups to overcome historical marginalization. Now, in Indian Constitution, the three different distinct reservations that we have are one are political reservations, as all of us are aware in Lok Sabha and state assemblies. And also then we have the main ones, as I identify them as, which have done more impact in each on everyone's life in terms of in public employment and in education. Article 15, subclause 4, Article 16, subclause 4 for SCs and STs and OBCs. And of course, my research of critically evaluating EWS reservation, which is under Article 15.6 and Article 16.6 of the Indian Constitution. Now, I'll go to the Constituent Assembly debates and Dr. Ambedkar because I think it's very important to understand what Baba Sahib did for us was no other country, very few countries until then have done it, and of course British had done it in India, but a constitutionally mandated affirmative action policy as we see it. India is really one of the first major countries to have that comprehensive policy. When you read Constituent Assembly debates and across 2.5 years, broadly speaking, one thing that sort of really comes out from those debates and Baba Sahib's fight for our reservation were two things. Number one is that not everyone and anyone can get reservations. This has to be limited to the constitutional term adopted, as we understand, of backward classes. And of course, Article 16.4 was present, and Article 15.4 came only as the first amendment to the Indian Constitution in 1950. But 16.4 was very clear in public employment. There shall be special measures to be taken in form of reservation policy. Now, Dr. Ambedkar's dilemma was, should we have communal quotas in India, where each and every section or caste, as we understand it, has certain share in the policy in terms of their numeric number. And we see that sort of logic coming up again during the Mandal debate, and I'll come to that. Dr. Ambedkar categorically rejected communal quotas in India. And my research sort of shows how through the back door, and their book already has analyzed this, to the back door, how successive governments, be it BJP, Congress, any other government, even Janta government, has established communal quotas in India. I show it through my analysis why there are communal quotas in India. Dr. Ambedkar's approach was that only certain sections of the society should get reservation policy. And these sections are back then called by British as depressed classes. Depressed classes, the constitutional term changed to scheduled caste because there was a schedule 1950 presidential order. I will not go into deep into that. The point of this is that the justification was historical marginalization. What we see is that, of course, there are seeds of OBC reservation already present because the terminology used is backward classes and how Mandal Commission and, of course, Janta government then implemented through VP Singh the OBC reservation for 27%. But the core understanding of extending reservation is number one, historical marginalization. Now, what we have to also understand in the same debate is that we as Dalits, and many people in this audience may not like that word. I've had debates personally, but we can reserve those debates maybe for the discussion. The importance is for us to understand is that the scheduled caste and scheduled tribe combined had the least amount of reservation in terms of number when compared to other groups. And I will explain why it matters. As of today, we have about 60 to 70% reservations in India, which itself is unprecedented in any other constitutional regime, as I've studied that. And the problematic aspect of it is that majority of it is not given to SC/STs, who are the most oppressed and historically marginalized groups. They're extended to OBCs or the erstwhile Shudra community, as we understand, despite having different experiences of discrimination that we have suffered. Only certain sections of Shudra population have suffered untouchability, whereas all of scheduled castes, as we understand, have been identified on the markers of untouchability and other social backwardness markers. Scheduled tribes is about their social exclusion from the mainstream of the society, and that was the marker as well. The reason to give this sort of background is to come to this whole debate about what we need to do with reforming the reservation policy. We have heard two, and I've read all the judgments of the Supreme Court from 1950 onwards until 2024, which is about 8,000 pages of judgments of the Supreme Court. And my analysis of the Supreme Court judgments, which will now come out in the form of a second book, shows and demonstrates that the argument against reservation predominantly happens when it's the context of the reservation for scheduled castes and scheduled tribes. When it comes to OBCs, we have seen, and especially upper caste groups, EWS, the judiciary has shown a more favorable approach in terms of upholding those reservation rights and stuff. Now, in here comes in the question of who are these people within scheduled castes and scheduled tribes who are advantageous, who are advantaged, and who no longer deserve, and I'm putting them in quote, deserve the benefits of reservation policy. We understand that in the OBC, in the Indira Sane judgment of 1992, the Supreme Court, for the first time, had this doctrine, the legal doctrine of creamy layer. Creamy layer means, and for OBCs, that if you have a certain economic indicator about a particular income threshold, and there are other thresholds apart from economic indicator, that itself shows that there is social and educational forwardness of that OBC category. Now, what we have seen in 1992, and my research shows that 1992 to 2024, that period, the Supreme Court has done nothing different than just borrowing from its own OBC-related jurisprudence, case law, and this doctrine of creamy layer, and just applying and pasting it to scheduled caste and scheduled tribe. Now, the problem with that understanding is, and subclassification, the question of subclassification was already ruled in favor, not in favor, but ruled in Indira Sane applies to OBCs. Now, in Indira Sane, it was very interesting, as we see, that the case was not about scheduled caste. It was about the 27% reservations for OBCs. But in there, they made a point very clearly that subclassification and the question of creamy layer does not apply to scheduled caste. And coming then to E.V. Chinnaiya case, 2006-2007, the Supreme Court again ruled that subclassification does not apply to scheduled castes for the reason that they are homogeneous in nature. Now, the whole debate at the Supreme Court, when the seven-judge bench in Davinder Singh 2024, when the judgment came out, it was very clear that the Davinder Singh judgment, the Supreme Court was rewriting its own law, legal interpretation of subclassification, but in particular, overruling E.V. Chinnaiya. Now, E.V. Chinnaiya said that two things, and one of them was the right thing to say. First thing is said was they're homogeneous. Scheduled castes are a homogeneous category, which means that there are no distinctions within scheduled castes as such, scheduled tribes including, right? Second thing, it said that empirical data should not be collected on the backwardness of scheduled castes. Why? Because we as scheduled caste groups hold a very important and a unique position in the Constitution of India. That is, that we are the groups which have suffered untouchability, right? And therefore, any exercise of wanting to collect data on the backwardness is itself unconstitutional. So, M. Nagaraj, the judgment which came 2 years later after Chinnaiya, changes that completely. M. Nagaraj waters down and says the government have to produce backwardness data to justify reservations for SC/STs. Now, Davinder Singh in 2024 does two things. It overrules, of course, M. Nagaraj to a certain extent, but also overrules E.V. Chinnaiya by saying that SC/STs are not a homogeneous category, and the fact that they have various advantage and disadvantage sections within them. And I think we have to go a little bit deeper into this, and I've written about this quite extensively, of the fact that whenever there's a debate about anti-reservation, the spotlight is never really on upper caste groups. It is really on us, SC/STs, that we are somehow rhetorically speaking. The argument is mostly rhetoric, it's not backed by empirical data. The argument by the other here and the other here is that we as SC/STs are, some of us who are more advantaged within our group are taking most number of benefits. I'm sort of watering it down, there are different ways of, saying this, but the crux of it is really that the most advantageous persons within SC/STs are taking those benefits. Now, those claims that are being made are not empirically founded. Whatever data that we have in front of us right now, even today, empirical data, we see that the most number of people within SC/STs who get benefited of reservations are not on the top 1%. And this is Thorat's paper in 2016. Professor Sukhdev Thorat and others wrote this paper. Very empirical data very clearly shows that even today, the most number of people who are benefited are from the lowest categories of scheduled caste and scheduled tribe. Now, why this debate? Because of, I think the political context here is very important. The Madiga community in Andhra Pradesh has been demanding a separate cut within the larger 15 odd to 16 odd percent of SC/ST reservations. The reason, and that has been a very big political demand. We have seen that the current government has very favorably, just before the Andhra Pradesh election, went ahead and supported Madiga community, which forms 50% of the subcaste group of scheduled caste within Andhra Pradesh, right? And that sort of led to the swing of votes directly in favor of course, TDP and the BJP alliance, as we understand. So the point of it is to understand is it's just not only about um, having targeted reservations. It is predominantly about politics. It's about getting electoral political gains by parties. And I think we sort of see this sort of also happening in Davinder Singh judgment. That's a Punjab judgment. It's nothing to do with Andhra Pradesh. But now sort of coming to the crux of what is subclassification and how it is different from creamy layer. Creamy layer doctrine, which now applies to scheduled caste in the context of promotion through the Jarnil Singh judgment, uh, says this, and don't quote me because I just recalling it from my memory. Says this that because substantive equality doctrine in the Indian Constitution applies to OBC, SC/STs, and everyone, EWS including. Therefore, because because OBCs have creamy layer applying as a principle applied to them as a community, the same principle must be extended to scheduled caste. The problem with that argument, and I've written deeply about it, is that nobody is talking about two things here. First, how economic indicators in the context of scheduled caste show social and educational advancement. How is there a link between economic indicators and social and educational advancement? There is no link. There is some link to the extent that it might show that there might be some economic affluence, but with different levels of experiences of discrimination. Shudras, OBCs never suffered untouchability. Some of them might have towards the lower rung of Shudra community, but majority of Shudras have never experienced untouchability. Rather, we know through empirical data that the worst oppressors of Dalits and scheduled castes and scheduled tribes are OBCs in the village and the rural areas, and even, of course, in urban spaces as well. So, sort of coming to that aspect about what is at the core of it, and my finding in my research has been that there is no understanding at all of what it means to be an advantageous Dalit in doctrinally, legally, doctrinally speaking. There is no doctrine at the level of the Supreme Court, as we understand it, which demonstrates what amounts to an advantaged or advantageous position of a scheduled caste person or a scheduled caste community. The problem with Davinder Singh judgment, and why I have argued is unconstitutional. So, by the way, Davinder Singh, by majority, ruled that subclassification for scheduled caste is constitutional. That is a legal position right now. My argument is that no, it's not, it's unconstitutional for multiple reasons, but I think the major reason is there's a contradiction which is at the heart of this whole debate. The contradiction is that the court rejects that scheduled caste are a homogeneous group or class of reservation beneficiaries when it comes to their backwardness status. So I will repeat. The Supreme Court says the scheduled castes are not equally backward or disadvantaged. Rather, they are differently, heterogeneously organized in terms of their backwardness. But when it comes to their forwardness or advantageous position, the Supreme Court assumes, and this is the word that I've focused on in my research, assumes that the homogeneity of scheduled castes when it comes to advantages or the forwardness position within subcategory is there. So on one hand, Supreme Court says scheduled castes are not homogeneous or similar when it comes to when they are disadvantaged. But those subcastes are similar when it comes to advantage position. And this itself, comes at the cost of treating caste identity simpliciter as a proxy for advancement, which basically means that we are using caste and subcaste categories on one aspect to deny this equal disadvantage, but also then the Supreme Court has accepted that there is equal advantage within those subcastes as well. Now, what are the implications of it? The first implication is that this judgment came on very poor data. There is no census level, caste census level data which demonstrates these divisions within the scheduled caste and scheduled tribe. And for the people who are joining in today, I would like to say that it is not a bad thing to think about reforming reservation in terms of allowing other communities to have preferential access or subclassification. But that subclassification exercise cannot be done in this arbitrary manner. The subclassification may not be the answer even, and I will come to that understanding in a bit, why subclassification of scheduled castes may not be the answer. Because nobody knows two things. First is a census grade data which shows those sort of divisions within scheduled caste, mandating disenfranchising of scheduled caste. It's a very important point. What Dr. Ambedkar vision told us that Baba Sahib never wanted subclassification to the extent that it will divide Dalits into subcategories, understanding very well, and Dr. Ambedkar of all people knew that there are gradations within scheduled caste. But he knew that for reservation policy to start and begin with, scheduled caste must be treated as a homogeneous category. And in order to challenge that, in order to not treat scheduled caste as a homogeneous category, what is important is we need to have empirical data which is census level. Now, there are some of these very poor studies done at the state level, and we all know all these commissions which are set up with political motivations are meant to do a particular task. Based on that data, Supreme Court has ruled in favor of subclassification. And I think that is itself is a problem. Why? Because first, it doesn't demonstrate that that subclassification is required. It doesn't show that a particular caste or a particular section within the community benefits from that reservation policy. Some state level data might have shown some erroneous empirical evidences in form of, for example, and I quote Mr. Gawai, and I'll come to his point. Justice Gawai, when he was at the Supreme Court, was very critical of the Mahar community indirectly, and I quote him: a particular caste in Maharashtra for the last 75 years, if they are taking reservations of 75 to 80% of the 13% available reservations, and there are some castes which have a sizable representation, but do not have even 1 or 2% reservation, would it not amount to perpetuating inequality among those classes as well? So, first of all, his figures are not empirically bound. This was just an observation without any empirical data. There is no data which shows us that, for example, the Mahar community coming from Maharashtra siphons off 70 to 80% of reservation. There's nothing. On the other side, Supreme Court's analysis itself lacks the depth of going deeper into the question of why, for example, there are certain castes who have benefited more than the other. And I know that I'm sort of short of time. I can sort of wrap up in the next 10 minutes, and then we can have a discussion. But the point is that nobody is going deeper into analyzing what is the problem. We and nobody, I think, in the joining on this call and even outside would argue that, for example, if the data shows that the Matan community or the Mang community, for example, in Maharashtra, are genuinely underrepresented, that they should be given more benefits to get highlighted or get preferential access to reservation policy. But it's not so easy to just think about providing access to reservation. It's about going more deeper, and this is what my argument is in my paper, the book that is coming out, is that there is no discussion about, or even a call for the governments to go deeper into why a certain section of caste benefited if they did the most, and why a particular section of caste did not, within scheduled caste, subcaste, did not benefit at all. Was it because certain sections themselves followed Dr. Ambedkar's call to get education and educate themselves and get benefits of reservation? Was it to do with socio-cultural reasons why some communities who have converted to Buddhism, for example, are more beneficiaries of reservation policy because of their approach towards education and taking hold of those opportunities more than the other castes? And then, therefore, if we start asking those questions, we go more deeper and try to understand what are the tools and mechanisms required to uplift people from within scheduled caste. Is this subclassification? Or is this something that we have to give them preferential access to certain education institutions? For example, encouraging, if the data comes out in census, caste census, that the real problem is, and what I assume is, the primary level education and sort of that sort of cultural difference that we see among different subcaste groups, then isn't the appropriate tool to involve here is to provide them those introductory access to education more than subclassification? Isn't then our job as researchers and as community to engage in that deeper? Because that's the Dr. Ambedkar's vision. Dr. Ambedkar's vision is to annihilate caste. Annihilation of caste will not happen at a meta level. Rather, it will happen when you start from a bottom-up approach of trying to understand what are the reasons why certain communities are left out if the data shows. And I want to sort of always have that caveat of if the data shows that at the census level. Second thing is that why this subclassification is so problematic and, in my view, unconstitutional is that it leads to a perception. It leads to legalization of a perception that a particular subcaste has benefited more over the other. What happens is, for example, if Mahar community in Maharashtra, because it has been at the forefront, of course, of debate, and also because we've come from the same subcaste as Dr. Ambedkar, there are multiple reasons why many of us who are coming from that particular community have been able to bridge those access barriers that other community members within scheduled castes may not have. But it is also very problematic and contradictory to our Supreme Court's own understanding that the whole of the Mar community is advantaged in some sense. this itself vitiates the otherwise very radically supportive approach to Supreme Court judgment have adopted towards reservation. That sure, uh, there may be some advantage sections in the society within SCSTs, and we need to tackle that. But then labeling a particular subcaste, for example, as an advantageous subcaste or a forward subcaste really disenfranchises the people within that subcaste, which may be even more backward, so to speak, than the other subcaste individuals. The point here is that we need, and whole book is coming out on this, that we need a uh, forward-looking, but also a doctrinal clarity at the Supreme Court, what amounts to social forwardness of scheduled castes. And this has been my argument that without a clear and categorical understanding of what amounts to social forwardness and when can reservations really stop for scheduled castes, having that clarity and having that doctrinal certainty, which is not based on only economic indicators, is a way forward. Of course, I'm writing about what could be the measures of social forwardness as we understand from the literature. But I think the key takeaway for us is that all of us must reject any imposition of economic advantage as the basis for social forwardness. There are two different aspects completely. Of course, they're overlapping in various degrees, but the experiences of untouchability, the experiences of social exclusion, etc., were when the basis of the reservation policy. Reservation policy must stop for any one of us, SC, OBCs, and especially upper castes, when we can empirically show that discrimination has gone away. We can empirically show that those experiences are not suffered by the so-called advantageous or forward sections within Dalits. My own research in Australia, because of which we were able to have a policy reform at the national federal level in Australia, demonstrated that the Dalit migrants from most predominantly from India and some other South Asian countries face high levels of untouchability in Australia. One mother, of course, narrated to me in Sydney that her children, as young as 8 to 10 years old, were treated as untouchables by the other upper caste groups in Parramatta district in Sydney because of their caste status. Students have narrated to me in Melbourne that a Hindu society or India Society of students in Melbourne University had a Diwali celebration. And on the poster of invitation, they had written clearly in bold letters that scheduled caste and scheduled tribe students are not invited. These are some of the instances, of course. I can go on forever and explaining that. But to end this conversation, I think I would start, I would stop by quoting Dr. Ambedkar when he said in the Constituent Assembly, and it's really at the back of my mind right now, that the reservation of seats must be for only a minority of seats. The moment you start expanding those reservations to everyone, then the whole policy collapses. Rather, the argument must be that how can we expand reservations for SCSTs other than curtailing them through these measures of subclassification? And I will stop there and open for questions. Thank you.
Thank you, Asang. I think Vishal has some technical issues, so he's just joining back. So just give us 2 minutes.
But if anyone has any questions, please go ahead.
Yeah, meanwhile, yeah, the floor is open. If anybody has any question, please raise your hand or ask your question in the chat box. I will take the question.
Is it okay if I ask the question directly rather than typing?
Yeah, go ahead. Yeah, that's fine.
Okay, thank you. So, Dr. Asang, can you explain like a little bit with the example? I think these contradictions that you talk about when the scheduled caste is being treated as a homogeneous community, right? And then you use the term like in the forward, it is being treated in a one way.
on the other hand, in the backward way, it is treated in the other way. Can you explain a bit more with the
Yes, sure,
example?
sure. So basically, Davinder Singh judgment 2024 of the Supreme Court, seven judge
Mhm.
uh, majority ruled that uh, subclassification is a mandatory requirement for scheduled caste. Government have to collect data and then adopt the policy. Now, in there are two aspects. One is whether scheduled castes are equal in terms of disadvantage and therefore homogeneous. Homogeneous in the context that there are disadvantage in the similar sense, right? And then the other aspect of it was whether they're heterogeneous in terms of the disadvantage. Supreme Court came to the conclusion, not unanimously, a majority of the majority decision, that they are not homogeneous. Their experiences of disadvantage within scheduled castes are varying and different, therefore heterogeneous. Now, this is the aspect of disadvantage. When it comes to advantage, so the Supreme Court said that because there are difference of experiences among disadvantage among scheduled castes, there are certain sections or subcastes within the scheduled caste which have more benefits than the other. And so they, on one hand, say there is no commonality or homogeneity within scheduled caste. But when it comes to advantage position, right, when they are advantage or forward, so to speak, quote unquote forward, they are not heterogeneous, they're homogeneous. So the contradiction there is Supreme Court on one hand says when you are backward, you have different experiences and levels of backwardness. But when you're forward, then your subcaste itself is a marker of whether you're forward or you're backward within that scheduled caste. And therefore, the heterogeneity and homogeneity functions in this way that backwardness, there's heterogeneity. People have different experiences. But when it comes to forwardness, the Supreme Court said there is homogeneity within those subcastes. So the whole subcaste itself is forward, which is not empirically true because there would be also heterogeneity within the subcaste when it comes to forwardness. I hope I've answered your question.
Yeah, thank you. It clarifies that.
Thank you so much. Any other questions?
So, JB Vasant, said Manish. First of all, I think congratulations completing your PhD. I think I can see a lot of news. So, if I'm up to date, then yeah, congratulations. If it's old
Thank
news,
you.
I'm sorry, I'm late.
No. It's very much neat. Yeah.
Okay, so congratulations. It's a proud moment for you and whole family and whole society. So, thank you, and
Thank you.
thank for your hard work. So, my question is like, when we are saying like categorizing or subcategorizing in the reservation or category, do it really make sense at this moment to discuss it? Because see, the reservation is a very, like, as per my understanding, it's a very broad topic. It's not reservation only on education or not only on job, but a real representation in society. When we are talking about when we see the count of university heads, mostly one community have the leaders there. We are not getting enough representation in college and university on professor level, teacher level, or judiciary system or media system. Is it really? I don't. Is it not think like it's too early to discuss about that? Because I know some communities growing faster and some communities not growing that fast. For example, you give the example Mahar community versus Matan community, and it totally makes sense because the way they have looking for reservation and education is different, and that making that more representation of Mahar community compared to Matan community. But if you see the bigger picture on national level, we don't have enough representation yet, I believe. So, don't you think it's too early that we're discussing about that type of segregation?
Hmm.
Like my
Thanks
my
for that question. Yeah.
yeah,
What I'll do is I'll take few questions. I think Pawan has had a question and then maybe
sure,
I'll
sure.
answer it together. Thank you for
Okay,
that question. Yeah.
thank you.
Pawan.
Hi, congrats, Asang. Uh, a quick question is what you said is like a really good. You explained it nicely. What I'm thinking is all these things will work if the government is just, for example, and want to give justice to all societies, right? But if the intention of government or ruling party is to create chaos, right, or to create, so it's to basically to divide scheduled castes so that they can win politics and all other things, right? In that case, does it really matter like how logical or rational reasons we are providing? And they're like, doesn't matter, we are not going to hear you, and only thing we want is like to divide this particular community and let them fight amongst themselves. So in that case, like what do you see the way forward?
Right. So I think two things here, right? So I'll start with the first question. Uh, I don't know about the timing, whether it's too early or too late. I think the approach has been, and I think I'll give you give you sort of a more broader answer about why this discussion. We have seen for the longest time that there has been a deep contestation of the benefits that we get in form of reservation policy. The contestation has predominantly come from upper caste groups, as we try to understand. And those upper caste groups and judges are present at the Honorable Supreme Court, right? And I know I am a lawyer myself, and I'm not ascribing any intention to any of the current sitting judge or the past judge in this way. But what we have to try to understand is where this is coming from. It's really not coming from predominantly empirical backing. It's coming from rhetoric. And sort of, Pawan, and your question also, why are we even talking about this? And it's sort of related to the first question as well. And I completely agree that one thing that we must do is to increase reservations, if anything else. There are 30 to 40 lakh broad posts in public employment which are not filled. There are dearths of SCST employees and professors at Indian universities. And we have seen that that representation question is crucial because despite the reservation policy, we did not require it to be curtailed, but we should be expanded and not expanded in favor of upper caste groups as we have seen that. AWS reservation, economically weaker section reservation, is the biggest scam, as I've argued, and on the Indian Constitution, really, because it fundamentally changes the character of what we understand reservation policy as. And the other aspect is instead of expanding that reservation in favor, there's a common thread across different reservations of politics. Reservation has been used in very different ways for different communities. In our case, especially, nobody is talking about the unemployment that our community faces and the lack of filling of, unfilled posts at the central and state governments. Right. Second is this whole question of division. In terms of upper caste, in 2019, when EWS reservation was 103rd Amendment was made to the Indian Constitution, it was done exactly 2 months before the Lok Sabha elections. We all know what happened during those elections. There was an attack against another country. Also, we had the data coming out, the most number of unemployed people in the world, in the youth were really in India. And this was because of the policies and of the government at that particular point in time. So we have seen reservation as a tool of division and doing electoral politics in the context of scheduled caste. Subclassification debate is about that. I think so. And the other aspect is fundamentally using those reservation as benefiting a particular group. In this case, upper caste in EWS category, which helps also politically to the present government and the ruling party as well. So I think the way forward is to stop expanding and stop expanding in favor of Shudras and upper caste. Upper caste and Shudras are the worst perpetrators of historical discrimination, caste-based discrimination, that we continue to face even today. And that has migrated outside of India to Australia. Of course, you are based in US, you know more about US than I do. UK, where I am based out of, and everywhere else where there is a major Dalit, South Asian diaspora. The way forward is to sort of start curtailing, and it's never going to happen. I know it's a death, for any political party. If they start reducing the reservation for a particular community. Right? And I think we have to think as a larger community of scheduled castes, Dalits, whatever Buddhists, whatever you want to call yourself as. But uh, Ambedkar's vision was that there has to be a social cohesion amongst us. And those tactics by political parties are to break that social cohesion for their own political purposes. So I think we can have like last question and then we can sort of wrap up.
Any questions?
Vishal, can I ask a question?
Yes, please go ahead.
Hassan, Devin, and wonderful discussion on the narrative that you're putting. My question, like there are a couple of questions that I may ask. So one is about you're talking about the EWS reservation, and when it was passed by the Supreme Court, there was no evidence of data of the backwardness among the upper class, right? And on the second notion, if economical backwardness is the reason to be considered, to approve reservations on that basis, this millions.
Sorry, you're muted, Vivek.
Yeah. So there are millions of crores of Indians, who come into the poverty. There may be a lot of intellectual students, who may avail the benefits. Isn't that considered as a discrimination? When it comes to the reservations, given to the people of upper class. When they have such a high level of distribution among to those group of people. So I don't know how these judges, who sitting in the upper the Supreme Courts are able to make these decisions, not given the looking at the data. Are they, just like blindfold, and completely, not considered the entire population who is completely remain backward even today, and the other thing about the reservation within reservation among our community, and it was very sad, the sitting Supreme Court judge from our community who benefited not to take a side of his own community, understanding how backwardness remains in our community even today. That is pretty sad, that the Supreme Court just from Gujarat had to come and dissent all
That's
among
correct.
that's pretty sad.
That's correct.
Right?
That's correct.
So
Yeah.
how do you, I don't know, you being a lawyer, you have PhD in law now and all that things, how do you, bring this understanding to the masses, because, you are young, and we really like to know about your perspective, how can it be dealt with?
Yes. So Vivek, I think those are very good questions, and I think I'm afraid I do not know answer to all of them, especially on why judges are ruling the particular way they are. It's a very difficult question to answer for anyone, let alone myself, because we do not know what happens in those higher echelon corridors of power at the Supreme Court. But I think one thing that my research indicates is that whenever there has been an expansion of reservation, it has always been ruled as constitutional by the Supreme Court of India, which is the most problematic part of it. I think it's sort of as if Supreme Court has a seat in New Delhi, as we know, uh, is sort of made to answer those very democratic questions which the parliament and the state legislation must answer. in terms of trying to address this agitation that when upper caste could not stop reservations that were given for us, right? There were multiple petitions, and in the past 75 years or now 80 years, one could really sort of see how it has been the case where it's very clear that Supreme Court has been made to uh, rule upon something which is so political, which is so political. Right? I think the second aspect is you're absolutely right. I completely agree with you on the aspect of EWS. EWS being an upper caste quota. I was one of the first people in India to point to that in my book, 2022 book. And I called it as a reservation for upper caste, middle class Hindu men. That was my line in my research. But the reason that I said that and I stand by it even today, and what we theorists, what we legal theorists do is we theorize based on what we see in data and let the new data come up. So when I wrote that book, the judgment was given 1 month later after that book by the Supreme Court in Janhit Abhiyan judgment, ruling it as constitutional EWS reservation. But the actual data that proved my point that why EWS is not about general category, but only about upper caste and a particular upper caste was because the way EWS is identified. EWS is identified using income tax ceiling limits, the creamy layer limit, as they say, so to speak. Creamy layer has some other additions in OPC, like IAS, politician, etc. But predominantly, it is the income line that is strong, the income tax. My research, my argument, which was theory, right, was proved in practice. Maharashtra government, when they took out the survey of who are the beneficiaries of EWS, right, in a particular year, I think this is 2025, 2 years later, they found 84 to 86% of EWS seats were taken by one community, Marathas. Marathas were able to capture that particular aspect. And I think what we have to take away from this is that reservations have been diluted in form of communal quotas. Every single caste group in India now has some or the other form of reservation. The second thing that we have to take away is that our rights as scheduled caste and scheduled tribe get diluted when the very aspect and the principle and the foundation of reservation is changed from historical discrimination to economic disadvantage. Because, and I will stop here by saying this, that reservations and affirmative action programs are not poverty elevation programs. They're not meant to come economic disadvantage. I have studied anti-discrimination law for the last 5 years at Oxford. And every particular theory and comparative analysis you do, you find that historical discrimination, what Baba Sahib said in 75, 80 years ago in his own writing, is the basis. Economic basis is not the basis. You're right, because there are millions of people who are below poverty line. But within those billions in India who are below poverty line, only a certain caste group gets benefited. Because what happens is, and this is what the second book will argue, is a finding that EWS quota, as much as everyone else wants to tell you, is only based on economic disadvantage. It is principally based on upper caste status. So whenever there is an aspect of invisibilizing caste for EWS, caste is at the very core and the prominent marker of EWS reservation.
Okay, thank you. And if I can ask one more question to you, just that would be.
Yeah, please go ahead.
Yeah, the question is about the distribution of equitable resources, when it comes to the reservations, right? We come from pretty humble and, poverty-driven society, that the people that we see today, those who are going in the private schools, and the kind of the coaching things are going on in India, it doesn't really benefit our community because, we remain to be at the lowest of that beneficiary unless there are some people from our community who have empowered economically, they are able to send their kids. But the majority of the population doesn't benefit.
Yeah.
On the top of that, the government is closing the schools. Government.
Correct. Correct.
So, don't you think, I'm just a little puzzled, to see how the Indian society, those when this
Mhm.
mainstream media, even projecting the backwardness in Indian society. Eight, the judges are not able to hear those news and have the society's reflections in their judgments. Doesn't how do you I don't know. I'm not a lawyer. I don't know how the lawyers being taught in the schools. Whether they are able to should they able to see the society's pain.
Hmm.
I don't know. Can you explain
Yeah,
how
but
that
I
is
think
being
Vivek,
reflected?
I think I will sort of just add to that by saying that we should not make the Supreme Court of India as a godlike figure that has answers to all questions. For that matter, even going back to Dr. Ambedkar, his very famous speech on 26th of November, whether the Constitution itself can be the answer or resolution for all problems of the society. You raise a very pertinent point there. We have not had a serious discussion about land redistribution and resources redistribution since the independence, for especially scheduled tribe and scheduled caste people. And I think that is a more systemic and impactful factor than affirmative action. I think what the Indian state, according to me, has got wrong, be it Congress, BJP, Janta, any government, is the fact that reservations themselves are not a fundamental answer to address inequalities in society. And this is sort of coming up significantly in different literature reviews and stuff. That reservation and affirmative action can only be one of the means to overcome historical discrimination. Now, understand something like caste discrimination has reinvented itself in new forms. Karl Marx, when he was back then, said that the caste discrimination might go away with advent of economic advantage and capitalism, modernity. Uh, Class may replace. And of course, Marx was completely wrong, and Dr. Ambedkar proved him wrong. That's the reality of it. You have to understand that it, it's an entrenched institution for 2,500 years or more, person, that will not go away from limited set of anti-discrimination measure in form of affirmative action. I think we need to, as a society, have look. Supreme Court is an institution which faces power, and the power struggle between the different branches of government keeps going on. Supreme Court is only one of the branches of the government. So I think it's also our fault to base too much reliance on Supreme Court, because Supreme Court is not, you know, immune of all the power struggles. Is not immune of what is happening outside there. Right? You give a right example. The retired judge, Justice Gavai, wrote one of the worst judgments that anyone can write, and it was really, according to me, against our community, about introducing in that subclassification judgment, why do we need creamy layer concept? I mean, my question to Justice Kavita, which I've raised on multiple forums, was why do we have to copy paste economic forwardness that is used for OBCs or SCSTs? Why can't we have a serious debate about when does experiences of caste discrimination stops to matter? And only then I think reservation should come to an end. Yeah.
Okay. So, final comment and questions for you. I know we take a pride, when our leaders, the young generations, taking such a high educational, from the institution, from the higher education, for the higher studies. I think that's really good, and creating the awareness among the masses, that's really important, because the having that understanding and bringing to the new generation really enlightens, and makes them aware about it.
Mhm.
The point I was trying to ask you about this, because we follow the constitution, because it
Mm.
is really dear to us. We are law-abiding citizens in India, and particularly, I would say from our community, at least most of them would be the law-abiding citizens, because they would honor Dr. Ambedkar's visions, of what the law means to them. And the point is, when we take step by steps approach, you know, when we see the political process doesn't assure us that security and the safety to our citizens, then what remains is, we know the media is totally sold out to a
Hmm.
particular group of political parties. The last resources remained with the in the constitution, in the courts.
That's correct.
When the court is also failing you, what
Hmm.
means in the people's hand is nothing, right? Then that is what we see. What the Gen Z is coming on the road, they're taking the law in their own hand. So I think it's very uh, sad to see the judges, who may have the kids of their age as well, not able to understand the point of what the needs of the kids are, not the needs of the societies in today's context. I think that's pretty sad. So I don't know. Where should the people go? Is that the only?
No, I
Uh,
think, Vivek, just
yeah.
to quickly answer your question, I don't think the Gen Zs are taking law in their hand. Rather, I think it's the beauty of our Indian Constitution and what Dr. Ambedkar told us back then in 1950, when we adopted the Constitution, is to give up the bloody methods of revolution. And also was very critical of satyagraha. And I think what we are seeing with Gen Z, they're doing is they're not taking law in their hand. Law in their hand basically means is they're breaking the law. I don't think they're breaking the law. It's a beauty of our Indian democracy that on one hand, we see that there are a lot of dictators in the past and in the present, of course, that have done what they have done to our country, but they don't last for too long. I think what we have to understand is Dr. Ambedkar has given us a constitution, and using those constitutional means, whatever we can do in terms of political consolidation and taking politics in our hand and not committing the same mistakes as the predecessors have is the way out. I think it's very much that we have to stick to the constitution, publicly mobilize within the limits of the constitution, as Dr. Ambedkar has told us. And what Gen Z has been doing is tremendously a great way of showing how we keep the democracy alive. Yeah. So I think
Yeah.
Vishal,
No, I
yeah,
didn't want to
Vishal, I
mean to
think
say that the what the agitation was taking the law in the hand. I just wanted to probably I did not get that word quick in my on the tongue. Yeah, the satyagraha is a part of agitation. To to show the displeasure towards the community and the supreme towards not the community towards the Supreme Court. And the political parties. That's what I meant to
Mhm.
say. Yeah, yeah. Thank you. Yeah.
Yeah, I think we can wrap up Vishal then. Yeah, I think it's about time, and I think
Yes,
yeah,
yes,
thank you.
yes, yes. Thank you for this session. Uh, Before we conclude the session, is there any announcement, Manish sir?
Uh, Vivek sir, do you want to say some words for Raju Kamble sir, late Raju Kamble sir? Vivek sir? Vivek Dada, are you able to hear me? I'm not sure. Okay. Yeah, I don't think we have any other announcements. So yeah, thank you.
Thank you.
So look at it.
Thank you so much. It is time to conclude our online Buddha Vihara, and I would like to thank Bhante for blessing us with the Dhamma talk. Thank you for the kids motivational story reader Mehit and Krantitai for the conducting the kids session, and many thanks to our guest speaker Dr. Asang Wankhede for the session, and thank you to all the participants who joined today. With this, we conclude today's online Buddha Vihara. Thank you. Namo Buddhaya. Jai Bhim.
Thank you everyone. Jai Hind.
जय भीम जय